Good afternoon, everybody, and welcome, both to those in the room and to those attending via live stream throughout New Zealand. My name's Emily Walton, and I'm a partner in Wynne Williams' Dispute Resolution team. Welcome to this first seminar in the ADLS Disaster Series. Please keep an eye out for advertising material for future sessions. The ADLS have asked me to also encourage you to put forward your suggestions if there's anything in this area you'd like to learn about. Right, and now to our presenters in order of appearance. First up we have Dr. Toni Collins. Toni is a senior lecturer at the School of Law at the University of Canterbury. She has an LLB honours and LLM honours. She's recently completed her PhD entitled The Doctrine of Frustration, Commercial Letters and the Canterbury Earthquake, so fairly on point, we might say. She teaches in land law and the law of natural resources. Her research interests include disaster law and environmental law. Toni's worked in private practice in New Zealand and overseas in the UK, practicing in various areas of commercial law and litigation and land law. The multitude of legal issues that arose after the Canterbury earthquakes sparked an interest in the area of disaster law, which culminated in Toni obtaining a scholarship and getting her doctorate. Following Toni, we will have Michael O'Flaherty, who is an associate at Mortlock McCormick Law. Michael specialises in property law with a particular focus on commercial leasing. He acts for Crown agencies in significantly large leasing portfolio and is well versed in the latest trends and issues with commercial leasing throughout New Zealand. Michael has previously assisted the ADLS in the drafting of the deed of variation of lease. Michael enjoys tailoring documents to meet his clients' specific needs, and that will be his focus today. Brian Tetford is the National Manager for Business Continuity for Asset Protection for IAG New Zealand. Brian is an insurance and risk management professional with over 30 years of global experience in underwriting a variety of commercial businesses, including property owners, retailers, manufacturers, defence contractors and energy companies. He has led teams of Indigenous underwriters, relationship managers and risk consultants in 16 countries across both established and emerging commercial insurance markets, including, I thought this was fascinating, Brian, the USA, the UK, New Zealand, Russia, Poland, Finland, Hungary, Czech Republic and Israel. His current position is as the National Manager for Business Continuity and Asset Protection for the Insurance Australia Group, IAG, based in Auckland. Brian envisaged and created an alternative risk management function to the traditional property underwriting division and launched new products for IAG's customers, including a risk consulting practice that helps keep New Zealand safe, with over 5,000 customer site surveys per year, providing bespoke risk management solutions. So, they are our speakers. I'll introduce myself when I bring in the tail end of the session later on. This seminar is directed about considering how your clients' leases would and could perform in a disaster. The session will run as follows. Toni will speak on the relevant issues. Brian will speak on untenantability, insurable interests and relevant insurance issues. After the break, Michael will speak on drafting and tailoring to client-specific needs, as we mentioned, and then I will try and draw some threads together with experiences that I've had, war stories really, based on the experiences in Canterbury following the Canterbury earthquakes. There will be time for questions at the conclusion of each presentation. So now, there we go, over to Toni. Pass it over.
So tēnā koutou, tēnā koutou, tēnā koutou katoa. Did you know that actually we have had that every year since 2002 we have had a state of emergency declared in New Zealand, other than for 2 years? And these have had to deal with things like flooding. I think I'm just having a look at the website that where I got these statistics from. Flooding, tornadoes, cyclones, fires, earthquakes. So we know that New Zealand is a country that is prone to these sort of disasters, and of course we have the risk of seismic disasters such as volcanoes and earthquakes. So they seem to be also, in terms of climate change, increasing on the whole, and these are something that we really need to turn our mind to when we're thinking about our clients and the commercial leases. Now, these types of disasters can have a significant effect on the business community. Right, oh, it's just under your seat there.
Sorry.
Now, if we remember back to 1990 and the flooding down in Queenstown, which had a significant effect on the central business district down there, you'll remember that the floodwaters came right up into the township. And in Christchurch, of course, as three of us here are from Christchurch, so a lot of our stories are to do with the earthquakes down there. The central business district was actually cordoned for 2.5 years. Now, that's an unprecedented response to a natural disaster in New Zealand. Imagine if your client is a tenant in a building that cannot access it for that period of time. The leases, as we will find out, don't necessarily cover all of these issues, and that's what we're looking at today. Now, of course, I can't start this presentation without talking about that elephant in the room, the coronavirus, which is now affecting us all. I've been talking about pandemics that may affect the business community for some years now, particularly in light of events like this, where we may have situations where a central city is closed down and the government may prevent public gatherings. And this has happened in Wuhan already. And I believe Emily's just told me today that the same sort of thing is happening in Hong Kong, although maybe not necessarily all about coronavirus. So these are certainly real events that could affect us and could affect our clients, and so we should be turning our mind to these situations. Now, interestingly enough, in Christchurch, I interviewed a number of lawyers after the earthquakes, and of course when the cordons were set up and other issues that arose, they immediately looked to their ADLS lease, which is the most common form of lease used in New Zealand. And they just couldn't believe that it didn't provide for the situations that were occurring. So we don't tend to look at these disaster provisions very much, thankfully, but I think that we do need to now take stock of them and see how we can improve them, remembering that the ADLS lease is really a template and it's something that we can actually adjust and use to put some bespoke clauses in depending on what our clients' individual needs are. So I've also put in the materials there that there are reports that came out in 2018 and in subsequent years that show that businesses, particularly in Auckland and some of our major centres, are not prepared for when disaster strikes. They do not have continuity plans in place, and this would include whether their lease is up to dealing with situations of circumstances that we're going to be talking about. So, when disaster strikes, does the law provide sufficient certainty for parties to commercial leases? What is the law? Where are the gaps, and how can we best protect our clients? So if we have a look at the latest ADL lease, so this is 6th edition, number 5, and we look at these two clauses, clause 26 and 27, which talk about total destruction and partial destruction of the premises. So now clause 26 deals with total destruction. So if we read that briefly, just so that you're with me with this clause, if the premises or any portion of the building of which the premises may form part shall be destroyed or so damaged as to render the premises untenable, then the term shall terminate at once. Or the second part is in the reasonable opinion of the landlord as to require demolition or reconstruction. Then the landlord may, within 3 months of the date of the damage, give the tenant 20 working days notice to terminate. The other part of that is in terms of the fair proportion of rent and outgoings, which we'll talk about a bit further on under clause 27. So that's total destruction. We know that the lease can be terminated under this clause, and there are two parts to it. First of all, if the building or the premises is untenantable. And secondly, if they require demolition or reconstruction, and that is in the reasonable opinion of the landlord. So not the tenant, but the landlord determines that. Okay, so a couple of issues arise. When does the lease terminate? Well, it says at the date of the destruction or the event that occurs, and that makes sense, that's obvious, and in a lot of cases it will be fairly obvious that that has happened. But in Christchurch we found that a lot of buildings weren't necessarily obvious from the outside that they were damaged. So there could be a period of time where you're not sure exactly when that date is that the lease may terminate, or where you would say it's untenantable. Now, that's not particularly helpful for a tenant who needs to keep their business going if they can't actually determine or know that the lease is going to terminate. So that has been a problem. Secondly, what is the definition or the meaning of untenantable? How do we know a building is untenantable and can be terminated? Again, I'll be coming to this shortly. So the second important clause in the deed of lease is clause 27. Now this relates to where a building has been damaged, and it sets out the repair and reinstatement process. So you'll see there that if the premises or any portion of the building of which the premises form part shall be damaged, but not as to render them untenantable, then, and the landlord's policy or policies of insurance have not been invalidated, or the necessary permits and consents are obtainable, the landlord shall, with all reasonable speed, expend the insurance monies to repair or reinstate the premises. But the landlord's not required to expend any more than the amount of the insurance money that's been received. That's point one. Now, 27.2 talks about the landlord using the materials and form of construction as the landlord thinks fit and shall be sufficient. Point 3, a fair proportion of the rent and outgoings shall cease to be payable as from the date of destruction. And finally, if the necessary permits or consents are not able to be obtained, or the insurance proceeds are inadequate to reinstate or repair the building, then the lease can terminate. So that all sounds reasonably clear, but what is reasonably adequate in 27.2? What is that the form of construction to such plan as the landlord thinks fit shall be sufficient so long as is reasonably adequate for the tenant's occupation and use? Who determines that? Bit of a grey area there. Secondly, onto my next page. Right, so 2 parts to this. First of all, the premises must be damaged. Secondly, they must not be untenantable. Anything that's untenantable comes under clause 26. A fair proportion of rent and outgoings has ceased to be payable. The landlord should use the insurance monies to repair and reinstate the premises and use reasonable speed. Now, first of all, they must be damaged. What happens if the building isn't damaged, but it is just inaccessible, such as the buildings were in the Cordon in Christchurch? These clauses don't apply. What if the building is damaged, but the damage can be repaired? Perhaps the damage is just minor. I'll talk about a case that refers to this later on, the GP 96 case. So there are still some grey areas in the clauses in the lease that we need to attend to, or at least be cognizant of, so that we can actually deal with these in the individual circumstances for our clients' needs. Okay, now the landlord is required to repair the leased premises with reasonable speed. Again, we're not quite sure about what reasonable speed is and who determines that. Now, in the case I've just pointed to there, GP 96 and PVG Securities Limited, this case is a case that came up recently, last year, about the application of insurance monies to the repair and reinstatement of premises. Now, in that case, the mortgagee, the mortgage extended to any proceeds of insurance over the property. So when the building was damaged in that case and the insurance proceeds were paid out, they were actually paid out to the mortgagee. Now, the tenant tried to point to the clause which said that the money should be used to repair or reinstate the premises. The Court of Appeal said no, that a mortgagee is not required to apply any of those proceeds to the reinstatement or repair of the premises. That the personal covenant within the lease is personal to the landlord and the tenant and does not apply to the mortgagee, even though the mortgagee does have binding obligations towards the tenant in terms of things like quiet enjoyment. So just a point to note there. So again, the issues arising under clause 27, what is the time frame for repair? That is not specified, and Mike's going to talk a little bit about that. Reasonable speed, I've already mentioned. Again, how is the proportion of rent payable to be calculated? So we say that the rent is to be, the proportion of rent will cease to be payable. What proportion of rent is it? How is that determined? Is it about the percentage of the premises that can still be used? And is the rent applicable to that? Most of the time what we found in Christchurch was the rent just stopped being paid altogether, and this didn't come up so much. I'm not sure about the litigation, and Emily may be able to help us with that, but most of the time we found that unless there was a significant amount, a percentage of the premises that could still be used, no rent was being paid. And I think that was a decision mainly that tenants took. Now, in the last point, the termination can occur under this clause if the landlord cannot obtain all the necessary permits and consents, and if the insurance monies are inadequate to actually reinstate or repair the property. So there is the potential to terminate under clause 27, even if it's only partial destruction. Right, now this term untenantable. Now, it's not found in the Property Law Act. Talk more about occupation and use. It's only found in the ADS lease, and I'm not sure why that is, whether the drafters decided that it had a different meaning to what was put in the Property Law Act. But anyway, that is what we are dealing with. There is also no definition in the lease, so we need to turn to the case law, and unfortunately the test for untenantable is not certain and is still, to this day, still unsettled. One of the questions that we really looked to in Christchurch was whether untenantable actually covers inaccessibility. Because if it doesn't, then we have to find some other solution for dealing with that problem. Now, the test has been the subject of judicial consideration in a number of cases, and I'm going to talk about a couple of those now. So the first case was, one of the cases was DFC and Sampson, and that was a 1992 case. Now, in that case, the lease was for 6 years, and the property was damaged by fire, and the time taken for the repairs were thought to be about 3 weeks, but ended up being about 10 weeks. So the tenant terminated the lease, and on the basis that it was untenantable. Well, the High Court actually held that it was untenantable because the tenant could not use the property for the purpose that it wanted to use it for. However, the Court of Appeal held that the damage was only transitory or temporary, so 10 weeks out of a 6-year lease was not sufficient to class the property as being untenantable. So the court really focuses on the comparison between the time, the length of the lease, the term of the lease, and how long the disruption is going to be to that lease. And that's come through quite clearly in the case law. Now, another case, Russell and Robinson in 2011, High Court decision, again relating to fire of property. The lease was for 4 years with one right of refusal. It was damaged by fire just after the lease had commenced. Now, there was 10 months of disruption, and in that case, the court held it was untenantable. Now, just looking at the factors that have arisen out of the case law, I've just summarised them here for you on the PowerPoint. So the things that have come out from the courts are these. You must look at the condition and the state of the premises. How badly damaged have they been? And how much does it affect the tenant's use and occupation and enjoyment of the premises? Secondly, there must be some degree of permanence. It can't be merely temporary or transitory. But again, how do we know? And all of the cases are different. It is on a case-by-case basis. Substantial interference. There must be substantial interference with the tenant's ability to enjoy, use and operate out of the premises. And other factors to take into account are things like the purpose of the lease, the duration, extent of the damage, estimated time for repairs, and the time left to run on the lease. Now, there was also a statement in one of the cases that said a building doesn't have to be completely destroyed for it to be untenantable. In fact, it could look perfectly fine from the outside. So it's not a matter of just a visual, it could be that it's untenantable even though it looks fine. And finally, the danger to the health and safety of occupants means a building is not habitable. I'm not telling you that means it's untenantable, but it could certainly be something that we could look at in terms of going to untenantability, but there's no case on that. So the determination of all of these factors is dependent on the particular facts of each case, and this makes the outcome difficult to predict, which is why I think we had so little litigation on it in Christchurch. Now, there are a lot of questions that arise out of this test, and they still remain unanswered. So what actually constitutes substantial interference and a degree of permanence? Is the assessment of untenantability an objective test or a subjective test? One of the cases I'm going to talk about in a minute, GP 96, Justice Chisholm talks about it being objective, but there was a High Court interlocutory application, so it's not completely settled yet, and sometimes tenants look at it as a subjective. What is the degree of relevance and importance of the stated purpose of the premises? So the fact that you've actually got the premises for a specific purpose that you need to operate out of, could that be a sort of serious question to be tried? And is it the original term of the lease or the unexpired portion of the term at the date of the supervening event that is more important, or are both important? So these are still questions that are yet to be settled. So this is the case I was talking about, GP 96 Limited and FM Custodians. Now what happened here, this was in 2011, soon after the February earthquake, I think it was about May, and it was an injunction to stop the defendant, the landlord, terminating the lease because the tenant wanted the lease to continue. Now the building was in the central business district of Christchurch. It had minor damage, mainly cosmetic damage, but the main issue for the building was that it was behind the cordon and it couldn't be accessed. Now the lease was for 6 years. 4 years of that had passed, but it had 2 rights of renewal for a further 6 years each. The plaintiff argued, or the landlord was arguing, that the building was untenantable. They wanted to end the lease. Now, Justice Chisholm held that it was arguable in this case that the building was still tenantable. First of all, because the damage was mainly cosmetic and not structural, but also, he said, because the lease had 14 years further to run, and therefore the fact that it was inaccessible, or the damage that had occurred to it, was only temporary or transitory period. So that gives rise to another question as to whether rights of renewal are to be calculated as part of the overall term of the lease, or whether they, or should they be, and he certainly did in this case. Now, his decision is probably based on policy considerations, because he did say that should he find that the property was untenantable owing to inaccessibility, then a lot of leases in Christchurch would all be terminated, and that would result in commercial chaos. So this particular point will need to be litigated further before we have a final determination on it. But it has major implications for untenantability, because it would mean that just about any lease may not be able to be terminated on the basis of being untenantable if you had rights of renewal, because it would probably mean that any disruption to it would take it way out of that comparison between the overall term of the lease and the disruption. So I would question that quite strongly. Now I can see I'm running out of time, so I'm going to move on. Oh, just back to that Precinct Properties case there. Now that's an interesting one too. There, that was a problem to do with the Kaikoura earthquake. The premises couldn't be occupied for 4 months in that case. The lease was for 10 years, and it had 4 years left to run. It was terminated under the clause 26 on the basis that it was untenantable. Now this was summary judgment proceedings that just came out in 2018, so a fairly recent case. The judge said he couldn't determine on the basis of untenantability in terms of no access, but he did say that the fact that there was an issue to do with the structural integrity of the building may go to the question of untenantability. So that's a new thing that's come out as well. Now, under clause 27.5, rent can be abated if there is an emergency, they're unable to gain access to the premises, the tenant cannot fully conduct its business from them, or there's some issue as to do with safety. And it will apply where there's a cordon, there's prohibition on the use of the premises, and there's restriction on occupation by a competent authority. So this is a new clause that has been inserted since the earthquakes in Canterbury, where we had the issue of access. Now, under clause 27.6, which is the next part of the new clause, the lease can be terminated as long as clause 27.5 does apply. So there's been some sort of emergency. The premises are not totally or partially destroyed. So in other words, clauses 26 and 27.1 don't apply. And the tenant cannot gain access to the premises for a specified period. You can now put a specified period in the first schedule to the lease. Just watch that you check this when you're doing the leases, and you're probably all aware of this now because the default period is 9 months. And for a small to medium-sized business, they simply cannot wear 9 months of a building that's inaccessible and having to pay rent for that. And finally, the party who terminates can establish with reasonable certainty the tenant is unable to gain access for that period. So again, that we're not sure what reasonable certainty means, and it also introduces a few grey aspects to that clause. Now, what does emergency mean? Emergency is actually defined in the lease under clause 47, and so it's not dependent on there being a state of emergency declared by a controller or a competent authority. So it's got to be, it's a result of any event, natural or otherwise, that may cause injury, loss of life, or illness, which is important, and it's obviously nothing to do with any act or omission by the landlord or tenant. So the no access in emergency has certainly helped us since the Canterbury earthquakes. It's provided us with a place to start in terms of issues arising that are not covered by clauses 26 and the first parts of 27. However, again, it raises the issues of what is a fair proportion of the rent and the outgoings, how do we determine that? And just remembering about that first schedule, the default period is going to be up for negotiation between the parties and will probably depend on marketplace power and conditions. Now, I see my time's running out. The rest of my presentation is about the Property Law Act, which you're most welcome to read through in the materials. Where the lease does not provide for particular issues, look to the Property Law Act, because where the lease doesn't provide for it, it's provided for in legislation. There is no ability to terminate the lease under the Property Law Act. It contemplates a continuing lease and just repair and reinstatement. But there are some other aspects that you can look at there in terms of yielding up the premises in the existing condition and the rent, which of course does not need to be paid if there has been an emergency or it's not the tenant's or landlord's fault. Leased premises can be used for one or more specified purposes. That is more to do with a legal use rather than anything to do with inaccessibility. And finally, you can look at non-derogation from grant and the quiet enjoyment provisions. Again, these are more relevant to probably when the building is being repaired or reinstated, and the landlord has that obligation to make sure the tenant isn't disrupted too much in terms of that repair and reinstatement. So check the Property Law Act, and there we are, finally. And if all else fails, could there be a common law solution? Now, I did argue in my thesis that in Christchurch, I believe the doctrine of frustration could have applied to the cordoned buildings, because the test for the doctrine of frustration is there, which is set out in the National Carriers and Panalpina case and Lord Simon. There are several tests for it, but this is quite a good one because it actually encompasses everything. When you think that frustration of contract takes place where there supervenes an event for which neither party are at fault, and for which the contract, i.e. the lease, makes no provision, and it so significantly changes the nature, not merely the expense or onerousness of the outstanding contractual rights and or obligations from what the parties could reasonably have contemplated at the time of its execution. So no one in Christchurch contemplated that they'd be shut out from their premises for 2.5 years. And it would therefore be unjust to hold them to the literal sense of that contract stipulations in the new circumstances. And in that situation, the law declares that the contract comes to an end. Now, in the National Carriers case, that's the first case that actually that determined that the doctrine of frustration will apply to a lease. It's now trite law that it does, but that was the first case in 1981. Now, in that case, just as a matter of interest, the lease was for 10 years. The reason the tenant had the lease of a warehouse where the total point of them having the warehouse was for storage. You've seen Panalpina on your way from the airport here in Auckland. The disruption was for a period of 18 months where the road and access to the warehouse was completely shut off, and that was done by the council. The lease had 4 years to go at the time of at the end of the disruption period, and the House of Lords held that it was not frustrated, that 18 months out of a 10-year lease with 4 years still to go was not disrupted, and they had to pay rent for the 18 months that they could not access their building. The doctrine of frustration is a high threshold to meet, so it is something that involves a fair bit of risk for your clients to take on, and it still remains fairly uncertain. We have got the Planet Kids and Auckland Council case, which is the leading Supreme Court decision on the doctrine of frustration in New Zealand and sets out the approach that will be taken. It's not in relation to a lease, but still the factors that in the test for frustration, you should refer to that case. The Supreme Court said that it involves a multifactorial approach and involves a consideration of a number of factors. One of the main things that was talked about in the overseas jurisdictions is that if the supervening event can be foreseen, then that really goes against you having a claim under the doctrine of frustration. The Supreme Court in Planet Kids case added foreseeability as one of but a number of factors and did not place any particular weight on any of the particular factors. So all of them need to be weighed up pretty much on an equal basis. So merely because something may not be foreseeable does not mean that you can write off the doctrine of frustration as a potential solution here. Now, just finally, and I know that Mike didn't mind me overrunning his time a little bit, I'm just going to quickly say about information sharing and access to justice. Finally, just the two of the problems that arose in the Canterbury earthquakes, information sharing between landlords and tenants, there was very little. Tenants did not get copies of reports of buildings, and you need the building reports in order to determine whether a property is untenantable. There was not a lot of that went on, and it could be to do with insurance as well, which you might be able to comment on. Secondly, access to justice. Remembering that commercial tenants, their only access to justice, and landlords of course, is through the courts. There is no commercial tenancy tribunal for them. So that is also a deterrent to to seeking a solution in this way. And in a lot of my research, the tenants continued to pay rent for buildings they couldn't access because they just did not wish to take it any further in terms of court proceedings. So those are a few thoughts for you. Thank you for listening, and I hope that you'll gain some help from some of the materials that I've provided for you. Thank you.
Thank you, Tony. Does anyone have any questions, either online or in the room, for Tony now?
None as yet online.
None as yet? Okay, great. Right. Yes.
My name is Ian Bassett. I'm a barrister from Auckland. I was looking last year or the year before last at the provisions of the ADLS lease clause 26.1 and 27.4 that are on pages 6 and 7 of your paper. They provide for automatic termination upon the happening of an event. It seemed to me from reading section 243 of the Property Law Act that such a clause would be void. If you marry section 243 with section 207, that's the interpretation section. The interpretation section of the Property Law Act says or refers to and defines a condition as including an occurrence of an event. So if you marry section 207, that definition of condition, with 243, section 243 subsection 3, it would seem to me that the automatic termination provisions of clause 26.1 and 27.4 are likely void. Do you have any comment on that?
Right. I haven't looked at those particular provisions, but I will certainly go away and check on those. The Property Law Act, of course, is no, I haven't at this point. Thank you.
There is actually some case law in England that seems to concur with that
Right.
view.
Yeah. Oh, thank you. Yeah, I will look into that further. Thank you.
Thank you. Brian, I think over to you.
Playing the part of Michael will be Brian. Thank you, Dr. Collins, and again, apologies for poor mobile phone management and having my ringer go off. Apologies for that. It's a pleasure to be here with the Society, speaking with you this afternoon. And one of the things we're blessed with in this country is magnificent, beautiful scenery, things from the beaches to the fjords. But also, too, as Tony shared with us, it is an environment that's ripe for disaster. Everything from seismic activity to weather-related events to volcanic eruption. And one of the things that the insurance industry really takes as its purpose is to help keep New Zealand safe. And it's important to know that New Zealand really relies on the insurance protection to a greater extent than most other developed countries in the world. It has a very high take-up rate for the purchase of property insurance, which we'll talk about a little bit later. But the issue at hand today is how will your client's leased property perform in a disaster based on his commercial property insurance? So what I thought to do today is really talk about getting to the heart of the matter, is understanding what the insurance contract is. And I don't want to stand here in front of your these esteemed students of the law and try to tell you your business. But I think what's really important here is that the contract itself, the insurance contract, is really the heart of the matter, how the policy will respond, and I'll explain why. I thought it'd be a little bit interactive. Sometimes insurance can cause people's eyes to glaze over, so I've got a couple of case studies I'll share with you and ask for a little interaction. And just so we don't have Rachel up and down with the microphone, I would like to get some feedback from our members here in attendance, but I'll repeat the answer just so we make sure to capture it for the folks that are listening in. We will get to the heart of the matter and again talk about how property insurance responds during disaster. A little discussion around tenantability and how the insurance contract reflects that and some of the gaps that we might have there. And then again, what I want to really sort of bring this home and is really talk about how to achieve risk transfer for losses from a disaster via property insurance coverage. So let's go back to some real principles. There are 7 principles that underpin an insurance contract, and I really want to concentrate on the first 4. But the first part is there's got to be utmost good faith in all parties to an insurance contract. That is to the insured or the policyholder, and also in the case of the insurance company as well. So if there's any misrepresentation, falsification of material, facts before or after a loss occurs, it might invalidate or limit the damages that are available under the policy. Also, it's important that the person with the contract that has insurance to cover their insurable interest in a lease has to disclose any relevant information or relevant facts. And again, if these are not adhered to as parties to the contract, then the contract itself can be void. Secondly, it's insurable interest, and I think this really gets to an important part in our discussion today about a lease. The Insurance Law Reform Act of 1985, it had a very unique view on what insurable interest is, and it says that a person whose use or benefit or whose account a policy or of insurance is made is required to have any insurable interest in the event for the person of a contract of indemnity against loss. It seems contradictory to the purpose and the principles of insurance, but what was clear is even with the Act as it's written now, it doesn't interfere with the principle that the policies on property are contracts of indemnity. And so it remains the case that the insured must demonstrate as a condition of recovery under the policy that a loss has been suffered. A commercial lease creates this insurable interest. And I've got a case study and we'll talk about the parties to the lease and where it does. But it's that insurable interest that allows property insurance to cover some of the responsibilities and some of the damages that a leaseholder can incur. One of the things I want to talk about and ask you to really reflect on is about the responsibility for placing and maintaining insurance. You need to think about the control of the policyholder, what their benefit is under the insurance policy versus the responsibility that they may pick up through the lease. So to that, I thought we'd have a little case study here. So this is a good chance for all of you to be underwriters for a few minutes today. If you reflect on this picture, the first thing I would tell you as an underwriter is this looks like a very dodgy outfit. From the get-go, this is a picture of me and one of my fellow managers, Mike. This was a promotional video we did in-house to talk about business continuity, and we happened to use a restaurant as a key. But I'll tell you, I wouldn't touch this risk with a 10-foot barge pole. So insurable interest. Again, I would ask the members here in attendance. Would the contract, the lease itself, create an insurable interest for the building owner? Anyone have a thought? Would the lease create an insurable interest for the building owner?
Is it an activity of business? Is that?
Oh, sorry. Thank you, Rachel.
So are we looking at whether it's an activity of business, like the landlord is in the business of being a landlord, and therefore, in terms of the insurance?
Well, that's a great point, and I'm sorry I've started out with a bit of a curly question. I would suggest, in the way that we look at this from an insurable interest point, is a building owner already has an insurable interest apart from any kind of lease. The fact that they own the property, the fact that they have a financial interest in the property would allow them to buy a property policy and cover it. So that's one of the reasons why that we can sell insurance for a building that doesn't have a tenant in it. Okay. Let's talk about the dodgy restaurateur. Does the lease create an insurable interest for the restaurateur in a building they do not own?
Are we talking business interruption insurance?
We'd be talking material, good question, material damage and business interruption insurance. The answer is yes. The lease itself creates an insurable interest if they have a financial responsibility to cover any of the assets that are covered off in the lease. And also for themselves, they would have business interruption exposures that they would need to protect. So we'll get into that. That's a really great question to talk about the BI versus the MD, as we would call it in my reckoning. How about, are there other parties that might be subject to insurable interest by the way of a lease? Well, since everyone's biting and jumping up and down to answer this question, let me share it with you. And first off, there are no wrong answers. We haven't, don't let my American accent put you off, please. Yes, actually, I'll give you an example. The restaurateur may need to lease equipment to go into the property. They wouldn't need the equipment if they didn't have a contract or a lease in place. So that's a way to stretch it out and think that that might create an insurable interest. Also, if the owner, if they need to take out a mortgage, that could be another party that has an insurable interest in the property that is also covered by the contract. So the key point here is that a property insurance policy does not cover the terms and conditions of the lease, but rather it covers the insurable interest and the liabilities that are created through the lease, subject to the property policy's terms and conditions, not necessarily the leases. Okay? We'll leave the restaurant. So thank you. It's great participation. Thank you very much. All right. So the next principle of insurance is proximate cause. And again, I think Tony did a great job of talking about some of the issues that really were impactful in the Canterbury and other events. But the key there is that it is the immediate cause and not the remote cause that an insurance policy will respond to. And within the terms and conditions of a property insurance policy, there are insured perils. These are certain perils that are mentioned specifically and contained within the policy. There are accepted perils. So there are some perils that are specifically excluded. An example of this is nuclear exposure. It tends to be a very traditional global exclusion under most insurance policies. It's not considered to be insurable because of the catastrophic nature of an exposure to a nuclear event. Then there are uninsured perils. These can neither be included or excluded, and tends to be as case history or the actual facts of the matter will determine if coverage exists. We'll talk about a little bit of how that goes in the Canterbury event. All right. So again, there's got to be proximate cause in order for the policy to respond. In my paper, I talk about some of the certain rules of proximate cause, but I thought, again, another example might help bring this to light. One of the things you'll figure out about underwriters pretty quickly is we like pictures of burning things. So you'll see a couple of those in here. So not sure if there are any James Taylor fans out there, but I call this case study Fire and Rain. All right. So the case I want to tell you about is Fence was able to remove the undamaged stock from a burning building, which protected it from further damage due to a fire. The stock was stacked in an open yard and was subsequently damaged by rainwater. So the question I have to you, what's the proximate cause of the damage to the stock? The fire or the rain?
Are we looking at causation?
Oh, the bravest person, I should have known, the person sitting up front would be on this.
Aren't we looking at causation? So the stock would not be in the yard had it not been for the fire. So therefore, you can show causation.
You've got it. You've got it. With the little curly one on this one, is there are some specific policy conditions and limitations about stock in the open. But one of the tenets of an insurance policy is that we want our customers to try to prevent further damage to property. So if they can show that they've done something to prevent further damage, an insurance company is very liberal in interpreting how the proximate cause might be tied back to the fire. But the two scenarios, and you've nailed it, if the rain had damaged the goods before the policyholder had an opportunity to protect it, then the proximate cause we would determine would be the fire. That's covered under the commercial insurance policy, so no worries. Even though it got wet, it's going to burn up, we're good to go. But let's say this tenant, or this building owner, was very happy the fact they survived the fire and decided to take a week off and head down to Queenstown or Christchurch. How about that? In that case, if they left it uncovered for a long period of time, that's unreasonable, and the rain would be considered as a new independent cause of damage. And this gets back to their policy conditions regarding property in the open, and it would determine how the loss is adjusted in the second scenario. I've shared with you some certain rules about proximate cause, which is worth a read. But this is a very complex issue within within insurance. What was the actual loss? And you can think that in an event like Canterbury, there was several different perils that occurred one after the other. All right, and we'll talk about that in a second. All right. So this is the question underwriters always get. So what's the policy going to pay? All right. Well, our esteemed colleague up front really picked up on two of the main areas of coverage. The first one's material damage. Think about this. This is the assets that the policy is looking to protect. And the perils that we protect these physical assets from can be divided into two key types of perils. The first are standard perils. This is what you think a property policy should cover. This is fire, this is flood, this is hail. These are the things that go bump in the night, right? But the second type of coverage is one that a New Zealand leaseholder would have to purchase as an addition to standard perils, and it's natural disaster. And again, this is pretty much what you would think it would be. This would be coverage for earthquake, subterranean fire, volcanic activity, tsunami, geothermal activity, hydrothermal activity, or the fire caused by any of those events. So if you had a scenario where you had a holder of a leased property, they were responsible for insuring that property through a lease, they had a earthquake, and then as a result of the earthquake, the pipes ruptured, natural gas filled up the building, and it burned to the ground. If they did not have natural disaster, that fire would not be covered. Okay? Then the second piece of this, and again it was brought up earlier, the second area that a policy will respond to is business interruption losses. This really gets to a lot of the risk management around disaster recovery and the events after Canterbury really bring this to light. This business interruption covers things like loss of insured profit, say reduction in turnover, increased cost of working, reduced margins because of a material damage loss. The first thing that has to happen in order for a business interruption to be covered is there has to be physical damage to the building or to the stock of the policyholder. One of the areas of business interruption is loss of rents. So we'll talk a little bit about tenantability, but if a building cannot be occupied because of a covered material damage event, the resulting loss of rents could be covered under a business interruption policy. Business interruption, just like material damage, you have to buy natural disaster in addition to standard perils. And there is a clause in most New Zealand insurance policies called contingent business interruption. So this is, again, an interesting concept when you think about disaster recovery. But what contingent BI does is it gives a sublimit of the traditional business interruption limits that a customer buys. Historically, it's about 10% of the limits they buy for direct BI, limited to maybe $1 million. But this covers things like prevention of access because of property damage. The road in front of the building has become damaged due to a volcanic event, so nobody can get in or out of the building. It can be prevention of access for injury, murder, or suicide. So if you had an unfortunate event like we did in Canterbury this past year, and there were businesses that could not open because of a criminal event, that could be covered as a contingent BI coverage. Prevention of access due to closure by any authority. Or if a business relies on a dependent business to attract customers. Say if the coffee shop next door is the entree for people coming by to buy cakes and pastries at your shop. If the coffee shop had a fire, you might be able to put in a case that you've had a contingent loss of revenue because you don't have as many customers coming through the door. Failure of utilities or customers or suppliers' premises. One of the things that is a real lesson out of Canterbury is a reliance on supply chain and be able to get goods and the accessibility of getting stock into an area. If that's disrupted, there is a loss of revenues and additional cost to go out and source that material somewhere else. Okay? So let's talk about insuring a property during a disaster. The Canterbury earthquakes really be very poignant, and I know a very personal issue for a lot of people in this room and on this call. But purely from an insurance perspective, it's an amazing case study. One of the things is that, to put it in perspective, is a $40 billion event. It again occurred over a very long time, 11 months of active seismic activity, and the recovery period in the CBD was many years after that. In fact, I will tell you that some of the Canterbury recovery facilities that we put up to settle out claims have just closed in the past 6 months. So this was a long-tailed event, almost more similar to some casualty or liability exposures like products liability or a PI loss. Really amazing to think about the event, how long it occurred, and the time it's taken to get recovery to some of our customers. It's also the 5th largest global insurance event since 1950. I mean, that's kind of amazing, right? Over 650,000 claims were lodged. But this is why I believe it's important for me to be here and talking to you about leases in a disaster, because the amount of insurance that was available to the people who suffered a loss. Over 70% of the losses were insured, either through public carriers like the EQC or private insurers like ourselves. To put that in comparison, Hurricane Katrina, which was 4 times the event, only had 40% of their losses insured. And there's still recovery efforts going on in that now. And the economic impact in most of New Orleans, some of the other coastal areas, it's going to last for generations because there was not that financial protection there. So, I won't put anybody on the spot here, but there's real questions about what material damages are covered after an earthquake. And again, it gets back to, did you purchase natural disaster, including standard perils? There's also a real discussion about how BI, or business interruption, would be triggered. But one of the keys here, and I think Tony picked up on it, is that if the building is not accessible but it's otherwise undamaged, unless there is a contingent sum insured available for us, quite often that is not an insurable loss. There must be material damage to the owned building in order for a BI coverage to be in effect. Okay. So that gets down to, what if the premise is untenable? Does it matter? Kind of. Okay. You mentioned the Russell and Robinson case, and that's a really good one. This was around a fire that occurred in Canterbury after the earthquake events. I meant to understand the really sad part about this. It was a 4-year lease, and the fire occurred the first day of the lease. And again, there was a tenant dispute, and tenability was interpreted objectively. And what it came down to was real basic principles for untenability. Okay. But the biggest one I'll tell you is that each case turns on its own facts. There's some general guidelines around this, which is in the paper that I presented to you. But the key for insuring a lease is that untenantability is not a clause within an insurance contract. But the impact, the fact that there was a fire, the tenant wasn't able to be in there for a long period of time, that could trigger a business income loss, which would cover the loss of rents to the owner of the building, and also would cover the additional cost to the tenant if they also bought BI coverage, if they had to move, or that they had some additional cost that was associated with their business. All right. Just mindful that we have a break coming up, and I'm not going to interrupt that. So just want to wrap this up. We're really talking about risk transfer. There are 3 key things that you need to know that came out of the lessons from Canterbury. First off, the certainty of indemnity, when each party covers their own insurable interest rather than transfers them via a lease as ironclad. The point here is that a lease may require the tenant to cover a building, or there may be other stipulations on that. But what we found in many events around the world, and was proven out in Canterbury, is that it is the best and most confident risk transfer occurs if each party to a lease covers their own interest. A couple of things to think about. You're not going to get paid on an insurance policy more than you have for your limits. You're going to be relying on an insurance company to be solvent at the moment that payment needs to be made. And also, you need to be aware of and to have identified and accepted the terms and conditions of the policy, including utmost good faith. One could imagine that if they had a tenant who stated they were going to be a dairy and decided to open up a meth lab and they burned down their building, there might be questions about utmost good faith in that insurance contract. Okay? I would rather be the building owner who unknowingly had that as a tenant rather than relying on a tenant who was involved in a legal act who burned down my building for insurance protection. Okay. Something else Tony talked about, the delays in restoring a property after a series of aftershocks occurred over many months, and in fact years for the shutdown in the CBD. And what's important to that from an insurance perspective, business interruption coverage has a period of restoration. You buy a limit of coverage and a length of time that it covers, typically 12 months. You can imagine if you're the owner of a building and were relying on your rents to be able to pay your mortgage and maintain your building, even if it wasn't damaged, but you had some partial damage and you got some payment, it's going to run out. If you don't think about the lessons from Christchurch, which is the period of restoration after a big event is much longer than after a fire. Finally, the enormity of business interruptions, loss of buildings that weren't damaged in the event but suffered a financial loss is huge. And you've got to think about the depopulation of the area. So you didn't have customers coming into it. You also didn't have workmen. You didn't have tradies or available. You didn't have materials available as required for the buildings that were damaged. For the buildings that weren't, you can't run a business and you can't collect rents if nobody's there. There's some other insurance considerations that I'll leave with you. Some of them I just picked up, but I'd say one of the most important ones here is that also with the transfer of risk to an insurance policy, there's a portion of the risk that the policyholder is going to have to bear. There is still indemnity if the policyholder has a deductible, either a dollar amount, a percentage of the building, or also some kind of time limitation on when coverage kicks in. That still meets the amount of indemnity in that the financial loss is being paid, but for the ability to have capacity to provide insurance or maybe for a cost savings element, a deductible is pretty common in most insurance policies covering a lease. Wow, went through a lot. Hope that wasn't too boring. How about some questions for me?
Yes, we do have one for you, Brian. In your experience, how much negotiation can occur over the wording of an insurance policy for a commercial premises?
That's a great question. I would say there is a tremendous amount of variability in policy wordings covering properties in New Zealand. A lot of it's driven more so by the actual intermediary that provides the insurance, the broker, or the fact that it's gone through maybe a scheme or a specific group that's providing insurance for the either for the location of the temple trade, and then also it's up to either the holder of the policy if they're going direct or through their intermediary to discuss changes in terms and conditions. But I would say probably you see more bespoke wording on larger or more complex risk, either to provide additional coverage or to restrict cover. And one of the things that we would talk about after a disaster and event, one of the areas about changes in negotiations around a contract might be for existing or hidden damage in an area that was known to have suffered an earthquake. That was some of the negotiations post Kaikoura in Wellington, that there wasn't a really appreciation of how much damage might have occurred prior to Kaikoura. Then we went in and we started trying to adjust claims, so some of the terms and conditions that are coming out of that event results around hidden or prior damage. Hope that answers that one.
Any other questions? Otherwise,
Thank you. There's just a question that kind of relates to that a bit, but it's actually for Tony. It's in relation to untenantability. What about if the damage is a latent defect that only becomes apparent a year or two later? Do you have the same rights?
Wow, that's a great question. I think it depends. If it's if it is damage to the building, it would have to be tied down to an event. When you talk about a disaster, specifically around an earthquake, it would have to require probably. It would have to require probably two technical experts getting in a room and having a chat about it. But there was quite a bit of that. One of the examples I'll share with you is Hollycore flooring was a type of building material that was very prevalent in Wellington. And what happened was that post-event, there were some some looks at the latent damage there, and I will tell you that if it was identified that repairs had been done to the floor previously and then damaged again, the case was made that at the very least a reduction in the damages that were paid by the contract.
And Tony, in terms of the lease and our tenantability under clause 26(1), how would that work in a latent damage situation?
I think you'd have to tie it then down to if the premises shall be destroyed or so damaged, and actually tie it down to some particular time or event when that happened. I'm not sure that it would cover something that had been sort of maybe,
I think just in terms of claims, I think that passage of time ultimately became quite a problem in terms of assessing damage from an insurance perspective and in terms of leasehold issues, because with the inflection of time, some of the damage sort of weathers and changes, and getting expert evidence and engineers to talk about that became quite difficult from an evidentiary perspective. So it's complex would be the answer to that question, I suspect.
And I'd also say, Emily, sorry, Brian, that the experts don't always agree either.
No,
and that's problematic.
Any questions from within the room for Brian in particular?
There's a hand up at the back.
Would the decision granting payment of insurance monies to the mortgagee rather than being used for reinstatement have been different if the mortgagee had consented to the lease?
That's a good one. Well, first off, the damages paid for the building or the insurance policy are for the repair of the building, and that is to meet the meet the financial needs of the mortgagee. They've basically put out a mortgage based on an asset, so the benefits of the insurance policy should preserve and reinstate the asset. So that's kind of the heart of the matter. If the funds were not being used to replace the asset, say if it was unable to be rebuilt, or for some reason that there was a question about the limits that were on the policy versus the mortgage, then that can become quite a difficult conversation. But that's really between the parties of the mortgage and the building owner or the person under the lease. From an insurance perspective, it's very clear. We have a contractual duty to pay out subject to our terms and conditions, to the financial loss, subject to the maximum limits that were purchased. The discussion in that scenario probably the mortgage company and the attorneys of the building owner, the party to the lease.
Tony's just going to elaborate a little bit on the answer to the last question about mortgagee consenting. So, there you go.
The question was about the mortgagee consenting to the use of insurance proceeds for the repair and reinstatement. It makes no difference. The court had a bit of a chat about that, because I think one of the questions in the case was a bit of confusion about whether the mortgagee had actually consented to the lease. So the court said it didn't matter, actually. And so whether or not the point is that the personal covenant of using that money for repair and reinstatement is between the mortgagee and they are not required, to comply with the personal covenants between the landlord and the tenant. And that clause 27.1 in terms of reinstatement of using the insurance proceeds for reinstatement and repair is a personal covenant between the landlord and the tenant. So the mortgagee was not required to or be bound by that.
That was the GP 96
GP 96 case. Yep. Beg your pardon. Thank you.
Great. Michael, please.
Okay. Well, hello and good evening, everyone. My name is Michael O'Flaherty. I'm an associate with Mortlock McCormick Law. The focus of my presentation and of my paper is drafting advice for tenants and landlords. So it actually works in quite well with Tony's presentation around some of the questions that arise from the current draft, and I try to answer some questions and give some advice to lawyers to give give to their clients themselves. The main thing is to actually think about the entirety of the deed of lease from the outset. As lawyers sometimes, and especially for clients, their focus can be trained on the first schedule, which contains all of the commercial leases. That's especially so in the case where there's an agreement to lease in place. So after the agreement to lease has been completed and everyone's agreed the commercial terms, that tends to be the focus for the deed of lease, but it's a good starting point, the clauses that are in place, but my advice would be to not try and treat it as the finished product, and it's not a one-size-fits-all approach. And just to specify, these are my views, so if they're not necessarily the views of ADLS, but it's for people to take away and draft themselves. My main tip is to think about your client's business and the client's needs. So if you're acting for the landlord, what's the best approach for drafting to suit the landlord, and likewise if you're acting for the tenant. And in my experience, I've been acting for both. So some of the clauses that I'll be discussing, the variations to the clauses, will be more for the tenant's focus or more for the landlord's focus. So as we've discussed, the total destruction clause is contained within 26.1. The areas I've highlighted are the areas that I see for potential variation. It is based off the ADLS deed of lease. However, if you've got your own bespoke leases that you use, this might also be quite useful, as some of the wording might be quite similar. So the first thing is untenantable, which we're all talking about today. It's the theme of the presentation. So there can be issues arising around what is and what isn't untenantable. My advice, one option available for people drafting leases, is to remove any uncertainty or to try and reduce the uncertainty around the word untenantable, an additional sentence there, so or incapable of being used by the tenant for its particular business. Ultimately, tenantability is the tenant being able to use the premises for the purpose for which they entered into the lease, and in this case it's specifying that if the tenant cannot use it for the particular business, because the premises themselves might be tenantable, but if they've got, say, a specific use of that premises, so if say they've got a building that's had partial fire and it's usually used as a cafe, and it can still be used as potentially an office facility, but it cannot be used as a cafe any longer, then that might be grounds for it for termination under this amended provision. And I've specified that rather than the term shall at once terminate, it grants the right for a tenant to do so. So it's solely becoming a tenant's ability to terminate rather than just the landlord's. And obviously, if you're acting for a landlord, you might want to push back on something like that. The second test, or second limb under 26.1 is requiring demolition or reconstruction. My question is, why would it just be the landlord that's entitled to make that decision? Obviously, it's their building, but one option would be that you amend it to be either party, so either party can form the view that it requires demolition or reconstruction. The tenants will be the ones that will no doubt be in the building, so they may be able to form their own view on whether or not the premises require demolition or reconstruction. And this amendment would give them the ability to do so. Obviously, there might be some difference of opinion between the professionals that have been appointed by both the landlord and tenant, if both do wish to engage engineers to say review whether or not the demolition works are required. An example might be the tenant notices cracks in occupation while they're in the term of the lease, and they consider that those cracks are more serious than the landlord considers initially. Obviously, the 3-month time frame is something that might restrict the ability for the parties to move quickly on those sort of things. The third option that I think we could introduce, or you might want to introduce if you're acting for a landlord, is, and this could be a standalone C under 26.1, is to add in an option for the landlord not to terminate the lease if they do not desire to repair the damage, and this would be at their sole discretion. So instances might arise where the premises have been damaged. They don't require demolition or reconstruction, but the repairs are something that the landlord is not interested in doing for one reason or another, and this is advice to people acting for landlords, and is to add in an option so that they don't actually have to go through with the provisions in 27.1 through 4. Some people might push back and say that that's unreasonable, but I guess it's thinking about what your client landlord would want. If it's a investment property for them and they're retired and this is their sole source of income, and they'd prefer to just sell the property rather than having to go through the stress of repairing it, then this might be something that you want to look at including. So just briefly touched on before, the notice period, and I'm sure Brian might have a different view around 3 months or 1 month being a long period of time, especially when it comes to things like the Christchurch earthquake. 3 months might be seen by some tenants as being quite a long time to have to wait to get the notice that the landlord decides that the premises do require demolition or reconstruction. So you could think about playing around with that, and I've just put here a sample down to 1 month, but you might be acting for a landlord and think, well, it's really not that reasonable to get the experts in during that 3 month period, especially if there's no access involved, to have someone assess it. So you might want to look at expanding on that to be 12 months. So that's really something to think about when you're drafting the deed of lease, and think about what your client's needs are, because if they won't want to be sitting there for 3 months, a tenant won't want to be sitting there for 3 months in a premises that they're not going to be able to use when the 3 months are up, and not knowing to them, and they might invest some money or some resources into the future of that lease, and likewise the landlord might want to look at expanding on that. So further considerations just around the total destruction. So what if the worst case scenario happens? And Emily and I were talking about this earlier. We tend to focus on the worst case scenario, which is not great. It didn't go into law, but that's fine. So the rental abatement provision, so fair proportion versus no abatement versus full abatement. So if you're acting for a landlord, you might think, or the landlord themselves might think, having an abatement at all is unreasonable. Obviously, insurance policies will be affected here. And likewise, if you're acting for a tenant, you might think that there should be a full abatement because they're not able to undertake any business activities from the premises. What I've done consistent through looking at the two clauses is look at the areas where there's a little bit of grey area, and how we can look at trying to make that a bit more black and white. So 2 notices, I'm sure there's probably an answer out there. So what happens if the tenant deems that it's untenantable at the same time that the landlord decides that it needs to be demolished? So the landlord's notice is obviously 3 months, so if they provide a 3 month notice saying, I want to terminate the lease because it's to be demolished, then the tenant in response has already got themselves ready to present a termination notice for untenantability, then there's the issue around the fair proportion or the abatement, but it's probably not that big of an issue. Upfront expense recovery is something to think about, and this is particularly relevant for landlords. They've got a financial interest in the lease themselves, so landlords might, as part of a negotiation, provide a substantial amount of fit out for the tenant, and that's covered by way of a fit out contribution. If you're acting for a landlord, they're not going to be happy to find out if there's a termination event following total destruction that they can't recover that fit out contribution, so you should make provision for those. So these are just things to think about. Hopefully that would be documented separately as well, so it wouldn't become an issue, but if it's a clause of the lease and the lease itself is terminated, that can cause some issues down the road, so just think about that when you're drafting. Reinstatement, so there is commentary around reinstatement within the deed of lease in respect of no access. There's a 5 working day additional period, which we'll touch on when we come to the no access period. But what happens in the event that the premises are deemed untenantable and the lease terminates? Are there any reinstatement obligations? So it might be worth just clarifying that. And then a right of first refusal. So this is something that would be quite rare, but a lot of the times, in a few of the cases I've seen where the landlord has terminated the lease because it was untenantable, and then entered into another lease subsequent on more favourable terms to themselves, the tenant has found out and not been happy and challenged the tenantability issue. So one item to potentially cover for tenants would be to include a right of first refusal. So in the event that the lease terminates after an event of total destruction, then the tenant is granted a right of first refusal over any subsequent lease. And it might be for tenants that have got a lot of different branches, and this is a particularly attractive location for their business, and they might have invested in the local community there, and they'll want to be able to go back in. Second clause is 27.1 through 27.4, so partial destruction. Again, I've highlighted the areas within that options for changing. So the first one, around 27.1, so I've just added a clarification. So the current wording of the clause reads that if the premises or any portion of the building which premises form part shall be damaged but not so as to render the premises untenantable, then there's works to be undertaken. This specifies that the landlord has also not given notice under clause 26.1b, so not only is it not tenantable, but it doesn't require the demolition or reconstruction works, which is probably just stating the obvious, but it's something that, again, is able to reduce the grey area. The time frame for repairs, so all reasonable speed. Again, listening to my co-presenters, they might think, coming from the events from Christchurch, that 4 weeks is completely unreasonable as a time frame for a landlord to undertake works. It's put in there as a suggestion of one time frame. And if you're acting for a tenant, obviously you'll want the landlord to be repairing the premises in a quicker period of time than the landlord may think necessary. So reasonable speed is another one of those grey areas. If we amend the clause to provide a specific time period, and this might be something that you look at when it comes to your insurance policies as well, then you at least don't have that period where the premises haven't been repaired, the lease hasn't been terminated, but you're not covered by insurance. So you want to make sure that you are thinking about these issues from the very outset. And I don't think it should be something that would be too difficult to negotiate from the outset if everyone's thinking about, well, what's the worst case scenario? Because to a landlord, 2 years might be reasonable, but to a tenant it might not be. So just think about this when you're giving advice. Insurance money is received. So this is looking at the difference between the insurance monies that are received by the landlord, which is the current wording. So under the current wording, the landlord needs to expend all the insurance monies received in respect of such damage towards repairing the damage or reinstating the premises. In many cases, that might not be sufficient to actually undertake the works, and also there may be a significant excess or deductible that applies to the insurance payment. In those instances, if you're acting for a tenant, it'll be likely that the premises is not going to be reinstated to their satisfaction, so you may wish to include something along the lines of what we've included here, which is adding in the value of the excess or deductible on top of that, so that the premises are reinstated to reasonable satisfaction for them. If you're acting for a landlord, you might want to push back on this, but it could be seen as something that's quite reasonable, given that obviously there will be excess or deductible in most cases. And touching on that, so what is reasonably adequate? And this was something that Tony touched on earlier in her portion of the presentation. So one suggestion I've got out, which is recorded in our paper and it's on the screens. So you can delete the grey area of what's reasonably adequate for the tenant's occupation and use of the premises, and replace that with the premises are reinstated as closely as practicable to the standard they were in at the date of the damage occurring. So that is quite it might be seen as quite a forceful obligation on the landlord, but it's something that you might want to think about including if you're acting for a tenant, especially considering a lot of issues are negotiated, and this might be one that you want to get in there. The time frame for termination, so again, it's unclear in the current drafting of the deed of lease what the time frame is. It just says the term shall at once terminate. If the permit or consent's not obtained, well, what's a reasonable time frame to wait for those permits or consents to be obtained? Again, I've put 6 weeks in here. People might disagree and think that that's unreasonable. A tenant might think, well, that's actually unreasonable because I can't wait that long either, given the nature of my business. So it's something to think about from the outset, as at least tries to provide a set time frame for everyone to work towards, and acknowledge that if there is a major event, there might be issues with obtaining those due to the local authorities being out of operation or having quite a backload, but it's at least tries to give a bit of certainty to people. and I've just specified that rather than the term shall terminate at once, either party may terminate this lease by written notice. And you may want to draft it so that it's the tenant's option to terminate if a permit consent can't be obtained, because they might think, well, if it's not obtained within 6 weeks, after 6 weeks actually everything's going all right, we're happy to continue in the premises, and rather than having it terminated, we're happy to wait out a little bit longer. And so instead of it being either party, it could just be the tenant. So this is just a little bit around application of the abatement. So it's just noting that it will be reduced by a fair proportion according to the nature and extent of the damage. So it's just an option for trying to give a little bit more clarity around how that abatement might work. So no excess and emergency clause. Obviously this is one of the more more recent of the three, and something that there might not be much case law on at the moment. The no excess period at the moment, and this was something that Tony touched on, is currently drafted to be 9 months. You've got to think about what's reasonable. So you'll look at the length of the lease commitment and the business needs. So, for example, and I put it on my paper, we recently received an agreement to lease for a client who's just leasing some temporary premises while their property's being repaired, and the temporary lease is only for 7 months with an option for a 1 month extension, and there hadn't been any change to the no access period. So should that, before it had been signed, and we've changed that thankfully, but had that proceeded with the standard 9 month period, then the no access period I guess would be of no use to anyone. Another option would be to make it solely for the tenants, and this sort of builds on my previous point around the obtaining the permit or the consent. So the tenant might be perfectly happy at the expiry of the no access period for the lease to continue for whatever reason. They might have obtained alternative premises, and they might have insurance policy to cover them. So one option is to think about varying it to be only a tenant option, because the landlord might think, well, I've actually got other plans for this building, I'd be happy to demolish it after 9 months, or terminate the lease, and do something with it after 9 months. An abatement of rent, so think about what insurance is in place. So you're not going to want a no access period that exceeds your business interruption insurance. So think about that from the outset, and it might be a question that doesn't really come up very often because people don't think about the worst case scenario. But in this instance, if we think about it from the outset, then hopefully we can plan better for the future. Reinstatement obligations, so clause, I think it's 20.4 of the ADLS lease, provides that the reinstatement obligation is extended 5 days post termination of the lease in the event where there's no access. So say there's no access and then the premises are terminated, as soon as access is reinstated. So in the event, if we take Christchurch for example, so it may have been 3 years for a building to be able to be accessed afterwards, and there was a 9 month no access period in place. So as soon as they've been given the access, they've got 5 days to reinstate, which might be unreasonable because the business may have, it's just probably quite a tight time frame. So it's something to think about amending if you, if you're concerned about the tenant's ability to reinstate quite quickly. And then finally, no access versus untenantable or requiring demolition or reconstruction, I think has been touched on previously. So just in summation, just on my portion of the presentation, my focus is thinking about the worst case scenarios from the outset. So think about if things do go wrong, is the current wording of the lease going to be satisfactory for my client's needs? Because they probably won't focus on the thoughts that you have at the stage, at the outset of the lease around Schedule 2 and how that might work. But it's probably more important to draw that to their attention, because I've found in my time advising clients that the issues that arise during the course of the lease always relate to the second schedule. People don't tend to focus on specific dates that are recorded in the first schedule. So think about the specific needs of the tenant's business. So just on that example again of the no access period, so you want to make sure that everything's logical. A small business isn't going to be able to handle a no access period, or might find it more difficult to handle a no access period of 9 months than a larger business. And finally, the ADLS lease is a great start. So obviously it's the most used deed of lease. It doesn't mean that you can't change it. And my understanding is that there's a revised version on the way, and it might address some of the issues that we've raised previously, and it's quite keenly anticipated. So gone through that quite quickly. So have you got any questions, anyone, or answers? Oh, questions and answers.
Thank you, Michael. Yes, there's one here about the change to clause 27.1, and I think it's the one that's at slide 64 about all reasonable speed. The person posing the question says, think it needs to be looked at a bit more closely. As drafted, if the landlord did not receive their insurance proceeds in 4 weeks, which is likely, could it not be read that they then have no obligation to repair?
Yep, quite possibly. And that's something definitely to think about. 4 weeks again, it was just used as an example of a way to amend it. But if the landlord doesn't receive the insurance policy and then can't undertake the works, then I guess the lease probably wouldn't be able to be continued. It's something to definitely think about, and I'm not sure whether or not insurance policies would be reasonable within 4 weeks, but it's something to think about in terms of you want the work to continue or the repairs to start prior to any insurance policies that you do have in place. So just something we discussed yesterday was around the business interruption insurance might be for 12 months, and the landlord might not receive their insurance payout before then, or they may not undertake the work. So I'm not too focused, I guess, on when the insurance money is received, but when the works are being undertaken. So the landlord might not deem it necessary to undertake the works, or may not be able to even undertake the works until after the expiry of your business interruption insurance. So a tenant might find themselves having to operate from a lease that requires repair and reinstatement, and they're no longer entitled to receiving any business interruption insurance, but they cannot enforce anything because reasonable speed might be seen as being, a year and a half because of the nature of it. So it's just trying to add a little bit of a defined time frame around things. But it probably does require some work in terms of, if you're going to use this, you need to think about when the landlord's likely to receive their monies.
Okay, thank you.
One thing to consider here, that it's it's in the insurance company's best interest to get a building operational, because it will reduce the BI exposure. Also, too, the contract is, again, utmost good faith. So both parties of the contract are supposed to behave in good faith. So what oftentimes happens is that the first question is going to be compensability of the loss. Is it a covered loss on the policy? And what tends to happen is, if it is quickly determined that it is, but it's a question about the value of the loss, conditions of the loss, latent defects, things like that. What will tend to happen is that there will be a partial payment, an agreement signed saying this is pursuant to the damages that we've identified. We're going to continue our investigation, but there's definitely a push for a prudent insurance company to try to reduce the BI losses as quickly as possible.
And just to touch on your earlier point, you might find that the insurance company is no longer solvent and can't pay it out, and then the landlords, how are they going to expend any monies towards the repair?
That's right.
Yeah.
Too right.
Definitely
Thank you.
issues. Any further questions?
This is a question for you, Michael, or indeed any of the others. Are you aware of the variation of terms of the deed of lease occurring, perhaps in the ways you've suggested, in the wake of the Christchurch earthquakes, for example, through negotiation?
I think it's something that happens regularly, regardless of the Canterbury earthquakes, but perhaps there's probably been a bit more attention drawn to those provisions as a result of that. Obviously, we've seen the inclusion of the no access period, so ADLS themselves are thinking about how to improve on that provision. But again, with the time frame for repairs in terms of getting money back, I guess those sort of things would need to inform any variations that you would be seeing. So someone might think, hey, actually putting reasonable speed's probably not going to be useful in this instance, because we don't know what that could be. However, we know from past experience that it took 12 months to get the insurance money, so let's try and specify 12 months as the goal to work towards.
Thank Thank you. Now, these are perhaps more general questions. What is the panel's thought on a situation where a lease is assigned and the sublessee is conducting activities that a landlord, the tenant and the mortgagee is not aware of, and an event occurs? What steps should the tenant and landlord take in terms of contractually and insurance cover?
Ooh, that's a good one.
Yeah.
Say that again, Tony.
Sorry, I'll say it a bit louder. They're in breach of the lease, first up. So there'll be those implications in terms of insurance.
Yeah, I think it would get back to utmost good faith. I think too, for the benefit of the building owner, usually the criteria is what a reasonably prudent person been aware of. So if this was something that was hidden, that was very clandestine, that would be reasonable. But if they came by the store one day and all of a sudden, instead of a dairy, they were operating a dance hall, and it was apparent what it was, and there was advertisements out, then that might have an impact on the validity of the coverage.
But also, I guess that would be an issue of business use in that instance as well. So there'd be multiple breaches to have to consider.
Thank you. What is the difference between the two insurance options in the ADLS lease?
So that's a full indemnity.
Yeah, indemnity versus replacement, isn't it?
Yeah.
Yeah.
Do you want to talk to that, Brian? Just those two? The insurance expert. So the two differences are the full replacement and reinstatement versus the indemnity of full insurable value.
Oh yeah, this was interesting. I got this question before the conference. So one of the things here is that there is a specific basis of settlement within the insurance contract, which is replacement cost. When they talk about here, full replacement costs for reinstatement, including loss, damage, structural windows, and other glass. There's also sublimits within most contracts on what is provided for as far as windows and glass. The other one is indemnity of full insurable value. Again, I've also heard the second clause being full sums insured as well in that. I think what it gets back to is that the contract that is going to determine the basis of settlement in the event of a loss is going to be the insurance contract. It will not include a specific wording like you see here, but de facto, if you're carrying your replacement cost coverage on your insurance policy and you have adequate limits that you've purchased, it should accomplish the same thing, but you would not see the wordings as it's listed here in most insurance contracts. The other thing too is that I would say that the full replacement and full insurable value is really up to making sure there's an evaluation on the property, that the value of the property is maintained and updated, and again, that would be to the policy holder to make sure that they're carrying adequate limits. There is a clause in some policies, for your benefit, it's not very common in New Zealand, but it's called an average clause. It's a insurance clause which says it compares what the person did cover over what they should have covered. And the idea there is to try to encourage them to have full sums insured. And there's a penalty if you're not within, say, 90% of what you should cover. But I think this card gets to the heart of that the values that are covered, the limits of the policy are really, that's the purview and that's the responsibility of the policyholder to make sure they carry adequate limits.
Correct, and I think that you're always going to want to go for full replacement cover rather than any indemnity-based cover, because a full replacement cover typically will reinstate a destroyed building with an equivalent building, and it will reinstate damage to a condition the same as or not greater or lesser than when it was new. So it's a threshold that means that you can get back what you had using today's materials and ensuring that you get a full response under the policy. I'll touch on that a little bit actually in my presentation as well. Yeah. Okay. Great. So, any more questions, or are we good to go?
None from the live stream audience.
No? Okay. Great. Well, My name's Emily Walton, as I said. I didn't introduce myself before very much, so I'll just quickly say that I'm a partner in Wynne Williams Christchurch office, and I specialise in insurance and construction law. For my sins, I've been heavily involved in earthquake claims for the last nearly 10 years, and so a lot of the subject matter we've canvassed today really resonates with me. During that time, I've acted for residential and commercial property owners, I've acted for commercial tenants, and I've acted for insurers. So I've worn a lot of hats and looked at these problems from lots of different perspectives. Today what I want to do is draw some threads together from what we've heard from Michael, Tony and Brian. There will be, I'm afraid, a degree of repetition, but I'm hoping that by telling these stories through actual claims that I've experienced, it breathes a bit of life into some of these situations. So, an acknowledgement, Tony, you're right. There are very few court decisions in relation to lease disputes coming out of the Christchurch earthquakes. You mentioned you felt that that could be potentially because the outcomes are uncertain. I'd add to that and say that I think it's not that the disputes didn't arise. They did, but people were pretty shattered and financially pretty desperate. And in the end, the idea of getting involved in long and costly court battles was simply not palatable. And there were, in the end, I think there was quite a lot of pragmatism that came to the fore, and that's why we haven't seen a huge amount of case law. The same thing with business interruption claims. Generally, people do the best they can to resolve a pretty difficult position. So, before I forget, there was one thing I wanted to say about one of the amendments to your clauses. You talked about amending clause 26.1b to state that to add in if the landlord doesn't want to repair the damage as an option. So at the moment it's like if they're not going to, but if they don't want to, you do need to be a little bit careful about that in terms of the interplay between insurance and leasing. And the reason for that is because under a material damage policy, if you have a reinstatement or replacement policy, if you choose not to reinstate, your benefits can fall to indemnity benefits. What that means is instead of going from replacement, as I described earlier, equivalent building, the same as when new, you can end up with a response that is a market value response or a depreciated replacement cost, which is a lesser response. So that is a decision that needs to be made with full awareness of the insurance consequences. And in fact, listening to this today, what really strikes me is that property lawyers looking at leasing really need to spend a bit of time with their clients and their brokers to understand the insurance ramifications of a lot of these clauses. Because I think what has happened through the claims that we've lived through, we've seen the interplay and the complexity that arises, and so understanding that at the beginning is going to be pretty important to serve your clients well. Anyway, right, so in my experience, the area that has caused a significant amount of problems is where the tenant has made significant contribution to the fit out or improvements to the demised premise or to the leased premises. That seems to be the area that I have found the most controversial issues. I'm going to use a couple of examples to sort of highlight this. So one is actually a reported case of Justice Heath from 2013, 134 Limited and JRF Holdings. Now, in that case, 134 owned a property in Victoria Street in Christchurch. Prior to the earthquakes, they agreed with JRF Holdings that JRF would contribute to the cost of a significant improvement to the building that would make it into quite a high-end art gallery. The parties agreed under an agreement to lease that the landlord would contribute $128,000 to the improvements. Ultimately, the improvements cost $818,000. The landlord contributed $218,000 and the tenant contributed just under $650,000. The parties agreed as a result of this that the tenant would have a reduced rent for the duration of the lease as a consequence of the contribution, and that on termination or expiration of the lease, the improvements would belong to the landlord. The lease was signed on the 18th of September 2009, so just under a year before the first earthquake. It had a 4-year term with 3 4-year rights of renewal. The formula for calculating the rental reduction was based on a 25%, 75% split that was effectively equivalent to the contribution to the improvements. The landlord took out a material damage policy over the building and had a sum insured of 1.45 million. The landlord and the tenant used the same broking company, and the brokers put on the insurance policy an endorsement that basically said that JRF as the tenant have paid for and done substantial renovation of this building, and their interest as such is insured under this policy. So there's an interest noted on the insurance policy. Then the disaster strikes. A year and a half later, or a year and a half into effectively a 16-year term, if we are looking at the rights of renewal. Property's damaged. The Canterbury Earthquake Recovery Authority recommends demolition of part of the building. The insurer accepted liability under the insurance policy, but said, we don't know who to pay, because both the landlord and the tenant are saying, pay. So 134 contended that the lease had terminated under clause 26.1 because it had become untenantable, and that when that happened, the improvements became its property, and therefore it should be entitled to full indemnification under the policy. It should receive all of the policy benefits. JRF contended that it had an insurable proprietary interest in the lease, which it retained at the time of termination and demolition, and it was entitled to some of the insurance money. Counsel for JRF submitted that there had been a partial failure of consideration, and that the return that was anticipated for the contribution of $650,000 had not been received, and compensation should be payable, or funds from the insurance proceeds. Justice Heath applied a purposive, one of those words that just doesn't come out right, interpretation of the insurance policy and of the leases, and looked at the commercial deal as a whole, and found that JRF did have a right to claim a portion of the insurance monies to compensate for the loss of the remaining value of the lease. But he also found that just shortly prior to the earthquakes, JRF had looked to sell the head lease to a third party and had agreed a price of $225,000. And he said if you were prepared to accept that, that's what you get. So JRF, having spent $650,000 a year and a half before, received a payment under the insurance policy of $225,000. But I suppose one could say that that's better than what 134 was hoping they'd receive. So, in terms of learnings from this, yes, it's acknowledged that a commercial lease can create an insurable interest in the tenant. The tenant can have the insurable interest, but it is always prudent to establish what the actual interest is. What is the nature of the interest, and ascribe a value to it if you can. I think when people are doing more complex deals around leasehold transactions, people use the idea of termination and expiration of the lease without truly turning their minds to quick, sudden or disaster-driven termination. And in these scenarios, there can be people left quite significantly out of pocket. So don't forget disasters. Don't forget disasters when you're thinking about these things. Okay, so the second example I have is a client that we acted for. They had quite a unique, I'm talking way too much. They had a unique residential business. They entered into a lease with their landlord. Pursuant to that lease, our client was to build a structure that connected to the landlord's building. Our client was to retain ownership of that building, that structure that they connected. Our client's customers were allowed to use the landlord's premises, and In fact, our client's business was quite dependent on having access to the landlord's facilities. Our client's buildings remained their property, but if it failed to remove them at the landlord's request on expiration or termination of the lease, they'd become property of the landlord. And the landlord had the right to demolish our client's buildings if they refused to do so at termination and claim the cost from our client. Our client took out their own material damage policy over their building, and they had a sum insured of $3 million. The landlord was an additional insured under the policy as was required under the lease. The policy provided for replacement cover, equivalent building, same as we knew. But like all material damage policies, as I touched on before, if you don't reinstate, you lose your replacement benefits and your policy response drops to indemnity. Canterbury Earthquake Recovery Authority, issued a notice requiring demolition of the landlord's building, but not our client's structure building connected to it. Our client's building was repairable and they wanted to repair, but the landlord didn't know whether they could rebuild, and if so, even if they could, when they could, given the ground conditions at the site. So our client was in a really difficult position because they kind of needed that building but to reinstate. And because that was a different form of lease, it wasn't an ADR lease, but essentially what happened is that our clients were able to find another location in New Zealand to rebuild with a similar sort of arrangement with the landlord, and the insurer agreed to cash settle their claim under the insurance policy. But the insurer required the landlord's consent to that settlement because they were an additional insured under the policy. And when we went to the landlord and said, could you please consent to this? They said, oh no, we're not signing that until we've sorted out all of the lease issues. And ultimately, one thing that became a big problem there was the demolition costs, because it was initially anticipated the demolition costs were going to be really, really significant. Ultimately, through quite a lot of negotiating, we did end up getting the landlord's consent to the insurance settlement. We did end up with a negotiated deed of surrender, and we did end up with an agreement as to the demolition costs. But it does show you that these things are quite tightly interconnected. And I guess the learning from that is staying on cordial relations with your landlord is a very good idea during negotiations. The next point was about partial destruction and timeframes for the landlord reinstating. It's really quite a complicated issue, I think. We certainly had a case involving a client who manufactured heating and ventilation materials. They were in a factory that they leased. After 10 months, their landlord said, actually, our factory's more damaged than we thought. We need to re-level the whole foundation. You need to get out for quite a lengthy period of time. Our client had a business interruption policy that covered their loss of revenue, and it had a period of 12 months, the indemnity period of 12 months. The indemnity period is the period during which the insurer will pay your loss of revenue, kicks off with the damage, not with the interruption to your business. So because the landlord didn't come to our client until about 10 months down the track and say, hey, you need to get out, our client had almost no cover for the period of time that they were going to suffer loss of revenue through being unable to operate out of the factory. Two quick points on that. One is it's quite important that your material damage cover and your business interruption cover is with the same insurer. I know that seems obvious, but it's not always, because the material damage and the claim accepted under the material damage policy is the trigger for the business interruption cover. The second point about that was, what was the second point about that? The fact that you can negotiate any length of indemnity period that you need. 12 months is standard. What became really apparent in Christchurch is that 12 months is not enough in the case of a natural disaster. So you can buy more, which gives you more flexibility. The alternative is some of the insurance policies out there have a deferment period. So you can negotiate a clause in the contract that says the indemnity period doesn't start with the damage, it starts at some later date, and that gives you heaps more flexibility, so it's quite a good idea to look into that.
It's also more cost effective, because if you buy a longer period of restoration, you pay more for it, because if you think about it, you're buying greater limits. But if deferment, even if you buy a longer period, you may not be able to start the work.
Yeah.
You may not have access to the building, et cetera, et cetera. So the deferment, I think, is going to be a really solid option, and may ultimately become a standard condition, not just an optional condition.
Yeah,
Great
that's
point.
good to hear, because I think the difficulties we're looking at here with the clauses in the ADLS lease and how long do you make it, how long's a piece of string in a disaster context. So that's interesting to hear that.
Yeah, and also I think it really sorry to take up
No,
your time,
go
but
for
I
it.
think it also it really sticks to the spirit of indemnity, right? Because during that period of time you can't do any work. That's something that's beyond your control. But if you defer when that time comes, it seems more reasonable.
Yeah. I totally agree. A couple more quick points. Learnings from that. Number one, sharing information. Tony, you've already touched on it. Actually, I think everyone's touched on it in some way, shape or form. For everyone to remain involved in the loop and knowing what's going on is really important. When the Canterbury earthquakes happened, it was an incredibly uncertain time, and when people are uncertain, they become hyper cautious. Nobody shared information with anybody, which ultimately created significant problems for people. So I think about in the lease drafting whether you want to have a requirement that parties share information or disclose information to one another. And then the other point is, and I don't know what you guys think about this, but from a non-property lawyer perspective, sharing the landlord's policy. So the tenant understands what the landlord can and cannot do is potentially quite relevant. I mean, I understand there's commercial sensitivities, and some landlords will be very reluctant to do that. I've certainly had to sign a few confidentiality agreements in my time to get hold of them, but it's just something to bear in mind. And that dovetails into the idea that that was touched on by Michael of excesses. Now, the clause that Michael suggested was that we add in a requirement that the landlord use the insurance monies and the value of the excesses towards the repairs. Since the Canterbury earthquakes, the excess situation for natural disasters has changed significantly. So we did have excesses prior to the earthquakes, a couple of grand. After the earthquakes, we have site sum insured excesses. They range from between 2.5% and 10% of the value of the site. So if you've got a $5 million building, your excess could be anywhere between $125,000 and $500,000. That's massive. So I think this is something that needs to be canvassed right up front when you're entering into the lease and work out how this is going to be managed. There is excess buy-down insurance that you can purchase. That's still around, eh?
Yeah, depends on where you're at.
Very
you
expensive.
might be able to find it in Auckland. It might be a challenge in Wellington.
Yeah,
Those
it's pretty expensive, is my recollection as well. But I think that's something that really could end up being a practical hurdle to everyone getting back on their feet. So it's something that needs to be borne in mind. And the final point I was going to make is in relation to the loss of access provisions under the ADLS lease. Brian, you talked about the common contingent business interruption extensions. That is the prevention of access due to various things, including damage in the vicinity or an order of a public authority or murder, or where you don't actually need that trigger of your own damage to get a return. I am constantly flabbergasted by how many people don't take out this extension to their insurance policy. It is a lifeline, and was a lifeline to a lot of businesses in Christchurch. It is typically 10% of your overall business interruption sum insured. For loss of revenue, your overall business interruption sum insured should be based on your revenue, looking at trends in your business, speaking really simply. 10% of that's not going to make you a rich person, but it might save you from a fairly negative business outcome. So ensure that when you're speaking with your clients about taking out tenancies, that they take that out. Brian, a question that I had for you though about that was the 10% sublimit. How flexible is that? Is there much room in that?
Yes and no. I mean, there's always some flexibility on it. I think it gets back to the, the nature of the risk. I think there'd be some questions about, what their exposure is. So to give you an example, there's, let's say if you had a client who was on the West Coast that was exposed to not just earthquake, but potentially flood, had limited access to, infrastructure, roadways and such. That would be very difficult to think about extending. Yeah. If you had someone you had other risk that's, a building that's not exposed to natural disasters like that, and in an area that's there's plenty of trade routes, et cetera, you might have a better go of it. The other thing I would say that unique to that coverage is sometimes there's a time period stand down. Yeah. So like deferment period might be first 24 hours there's no cover. So it wouldn't be if someone turned off the lights, for a day or two. It really was intended to be an event.
I suppose one example of that might be the convention centre fire here.
Oh, perfect.
It's likely that because of the length of the stand-down periods for those BI prevention of access clauses, there may be difficulties with people recovering their loss of income or loss of revenue during that period because it was too short, even though it probably felt really long at the time. Right. That's me. So if, yes, question. Yeah, please.
Just Ian Bassett again, a question for Emily.
Yeah.
You mentioned that litigation in Christchurch was, there wasn't much of it, due to cost in terms of people taking cases to court. Was there any, my question was, was there any consideration given to tenants or landlords grouping together to apply for a declaration as to the meaning of specific words in the ADLS lease?
Yeah, so first point to clarify, there wasn't a lot of litigation in terms of lease disputes. There's been a heap of litigation otherwise.
Of course.
Secondly, there were a couple of organisations that came in from overseas that had litigation funders behind them that were looking to bring those sort of class action claims. And you might recall there was
I wasn't referring to class action, I was more referring to one party making an application funded by others for the purposes of a declaration as to meaning.
Not under the ADLS lease. There were in relation to other insurance issues and other issues, for example, multiple events and the Ridgecrest stuff. Not that I'm aware of in terms of the ADLS lease specifically, no.
Thank you.
One question is about what bearing does the type of disaster have on drafting leases to try to cover eventualities that might arise?
Yeah, I guess you'd look at the the area might be one consideration. So if you're drafting a lease for a client who is in an area that's subject to seismic activity or potentially coastal erosion and those sort of activities, that would come into, maybe you look at a different type of no access period, or you might look at those being specific events that are identified for termination, because the landlord might have a view on the likelihood of that affecting the term of the lease, whereas the tenant might form a different view. I guess geographic would probably be the one I can think of right now, but I'm sure there's other considerations.
The other one that springs to mind is pandemic type disasters, and I was talking to Tony earlier about the New York Times reporting that one of the casinos in Macau is losing 2.6 million American a day through enforced closure as a result of the authorities' shutdown. If they're leasing that casino, that's a pretty significant problem for them. So yes, geographically, in terms of some disasters, and all indications are that pandemics are likely to become a greater threat moving forward. So I think always have the idea of the prospect of something happening unexpected that could really throw the cat amongst the pigeons should be in your mind, I think, all of the time.
Yeah, last word of caution from that. It's not to be gloom and doom, but the other thing is, we're definitely seeing a change in weather patterns.
Yeah.
The Canterbury hailstorm, as an example, we're seeing that more intensity out of typhoons, hurricanes, and other weather-related storms. Warming oceans mean they're going to dip further south. The intensity is going to be greater, less predictable. So I think it's one of those things, if you're in a coastal area, forget what historically has been your exposure. Assume that it's, that's a reality, that chances of having an event are going to be greater.
And can I just add in here too that we're very understanding that in practice a lot of leases turn up on your desk that have already been signed, and that poses challenges for you drafting out there if you're wanting to make these amendments and or additions to the lease. I was just talking to Mike about that. Have you got anything to say about?
Well, there would be agreements to lease come through quite regularly because other people might consider that there's more importance in getting them signed before the solicitors have an opportunity to have a look at them. And obviously there's a reference, if you're using the agreement to lease from ADLS to using the ADLS deed of lease, and some parties might form a view that because it refers to using the ADLS deed of lease, then the terms of those of that deed of lease is not up for negotiation. So I guess think about it from the very outset, from the agreement to lease stage, if there is anything that's particular to your client's business that you want to include ultimately in the deed of lease.
Thank you. Just one more question. Indemnity to full insurable value surely cannot mean replacement or reinstatement cover. Surely it means the best the landlord could obtain if he or she sold the property on the open market, less the value of the land.
Meaning, sorry, just to clarify, when I mentioned indemnity value being either the market value or depreciated reinstatement value, for commercial property it is more often the market value. Because typically commercial property is owned as an investment. There are some scenarios where that may be different fact dependent. If, for example, the building has specific characteristics that make it desirable for that individual and they were always planning on retaining it. There has been some guidance from the courts around that, but commercial, more often than not, market value.
That brings us to the end of the seminar. Just a few matters in closing. So a heartfelt thank you to Tony, Brian, Michael and Emily for their preparation, presentations and materials, and to Emily for chairing. I hope you will have found the content informative and the presenters' insights helpful for your drafting and advising of your clients. On behalf of the team, ADLS CPD, thank you for attending and I wish you a pleasant evening.